Well, there are a number of new developments in trade secret and non-compete law, one of which is a new federal law called the Federal Defend Trade Secrets Act. There have also been a couple Minnesota cases recently that have shaped non-compete law more generally in our state. To take full advantage of the Federal Defend Trade Secrets Act, employers have to revise a number of internal documents. One would be employment contracts, independent contractor contracts, and consulting agreements, and also their employee handbooks, because the law says that you have to have certain magic language in those documents in order to be eligible for all of the remedies that are now available under that law. There's a recent Minnesota decision where a court refused to enforce an old, vague, overbroad non-compete agreement, which is a good reminder to employers that they should be evaluating old non-compete agreements they may have with their employees and seeing whether they need to be updated. And one aspect of that often trips up employers is that if you have a non-compete with a current employee and you want to update it or change it in any significant way, the employer has to provide new independent consideration for that new non-compete agreement. One of the questions we get on a regular basis from the companies we work with is, what can they do about an employee who is engaging in unfair competition, or a former employee, when the employer, for whatever reason, didn't obtain that non-compete agreement? So there's no non-compete contract at play. And one developing area of the law is fiduciary duties. And an employer may still have a claim against a former employee who's soliciting employees or soliciting customers if the employee engaged in those competitive activities before their employment ended. So not having a non-compete agreement isn't necessarily a license for an employee, former employee, to go out and compete unfairly. One thing we suggest employers do is remind their employees about those fiduciary obligations so that they can take full advantage of the laws that are available if they need to pursue an action against an employee down the road.